Welcome to the program. My name is Marty Shenkman. I'm joined by Jonathan Blatttmachr, Alan Gassman, and Abby O'Connor. And we're going to talk about a recent Delaware asset protection self-settled trust case that I think has important implications to planning, especially now post, I got to get used to saying the acronym OBBBA, the Big Beautiful Bill, and we're going to explain why. I think we're very fortunate to have Abby O'Connor participating because she can give us some perspectives throughout, hopefully, on a institutional trustee's view of some of the things that were done or were not done, which I think is very helpful because my personal feelings are that if you're creating a self-settled trust, you really do want an institutional trustee for independence. And in many cases, you have no choice because you want situs in a trust-friendly jurisdiction. Before we get started, we're going to have a quick comment from two of our sponsors, Peak Trust, Jonathan Brandt. And I may say before you speak, Jonathan, that I set up my own self-settled trust in Alaska within 6 months of the statute being passed. I think it was passed in '97. So I've had a self-settled trust with Peak for a very, very long time. Jonathan?
Great, thanks, Marty, and welcome everyone to today's webinar, and thanks for attending. My name is Jonathan Brandt, and I'm a fiduciary officer with Peak Trust Company, and we are honored to be able to sponsor today's presentation. A little bit about Peak, and that's the Peak Trust Company offers trust administration for sophisticated estate planners, and we offer a full range of trustee services. We serve families and their trusted advisors, offering flexible and customized administrative services for all types of trusts. If you have any questions, feel free to reach out to myself or any member of the Peak team. And with that, we hope you enjoy the webinar. Back to you, Marty.
Let me add to the plug for Peak. They have entity in Nevada and a separate entity in Alaska. So if you're doing multiple trusts or trust for each spouse or for a single, why put them in the same jurisdiction if you can sort of up the ante and have them be more independent? Teresa, you're going to tell us something about ILS.
Absolutely. Thank you, Marty. Interactive Legal is pleased to sponsor today's presentation. My name is Teresa Bush. I'm the Director of Education for Interactive Legal, and I'm also part of our team of content attorneys. We provide an online automated document assembly system drafted by lawyers for lawyers. It is not AI. We get asked that sometimes. Our wealth transfer planning system includes a domestic asset protection trust, so I'm looking forward to learning about this case today. Our document also includes lots of different options to bring in provisions into the trust instrument automatically. And as I mentioned, we have a team of experienced high net worth estate planners behind our documents who we work exclusively with and for our subscribers. You can get more information at interactivelegal.com. You can read recent blogs, sign up for our speaker series webinars, or schedule a live demonstration. So I will turn it back over to you, Marty.
I have used ILS to draft self-settled and asset protection trusts and lots of different variations. And to me, one of the real powers of ILS is that you can get so many different variations to tailor a trust for a client. The one caution I would give is if you have no knowledge or experience with an asset protection trust, yes, you can draft it, but you still want to make sure that you address the planning and administration. This case that we're going to talk about, and Alan gets credit for the slide deck, he put it together, but at the end of the slide deck are a lot of slides of practical implementation considerations. And that's really essential. Even if the trust is the greatest asset protection trust possible, if it's not administered right, which is why I like to have an institutional trustee, period, it's not going to work. In this case, and we're going to get into it, address some of the very interesting issues that we've all pondered on asset protection plans, not just the trust document. So Alan, you wanna start us off with a little bit of an intro on the trust? I mean, the name itself is pretty cryptic, to say the least.
Well, I'll say that a gentleman established an asset protection trust in Delaware in 2007, and seems that he was solvent and doing well in 2007. He probably was not a detail guy based on what you see here. And he also, like many people, didn't like the idea of paying trustee fees. So he pretty much ignored the trust for a number of years, like people do. But then I'm sure he held the trust in very high esteem when he later had judgments against him and people chasing him literally all over the country here. The trust was competently drafted and competently funded, it appears. And the question really here was whether the Delaware Chancery Magistrate, which is a fancy word for the Delaware judge in court, would set this trust aside because so many of the details were ignored. And so many of the actions that were taken were things that Marty would not have advised him to do. Let's put it that way. And the long story short here is that the court said, hey, you got a Delaware trust. It holds up as a Delaware trust. You have a Delaware statute. It says creditors can't reach in. You have fraudulent transfer actions going on in other states, including Illinois. But here you are today asking me, a Delaware judge, is this a valid trust or is it an invalid trust? It's not his alter ego, it's a trust. He signed a trust, he put things in the trust, he eventually paid trustee fees, and we're not going to disregard this trust. It was interesting to me that they tried to challenge the trust in Delaware. I would have thought that they would have challenged it in a different jurisdiction like Illinois, where the judge in Illinois might not have been quite as friendly towards this trust as the Delaware judge was. It was also interesting, and Marty pointed this out, that when this trust was formed in 2007, Illinois had no creditor protection trust. Michigan, sorry. I meant Michigan when I said Illinois. But when this trust was formed in 2007, there was no Michigan Asset Protection Trust statute. But before this action was filed, Michigan did pass an asset protection trust statute. So some of the tea leaves here may indicate that if you're in a state that did not have an asset protection trust, when your client domiciled in that trust set one up in Alaska or Nevada or another good jurisdiction, and then your state tide changed and they have later now endorsed these, you may be okay. And that would make sense because you wouldn't want to have to start another one.
Alan, can I just interrupt? Jonathan, Abby, do you have any thoughts on that? The trust was set up in 2007, and I think Michigan and the actions that led to the case were in 2014, which is, by the way, a huge fact. It was set up long before needed, which is something that is really one of the most important things, I think, to do. But the Michigan legislature didn't approve DAPT legislation in Michigan. I think it was 2015. It was after, I think, the cause of action. Does that save it? How do you feel about the timing of when it was formed? There was no DAPT statute in Michigan, and later there was by the time the Delaware court heard it. Any thoughts on that?
Well, Marty, it doesn't seem that the court cared much about that. It didn't
mention it.
Didn't mention it one way or the other, so it was kind of irrelevant. I think that the restatement of trusts provides, I can't remember whether it's section 270 or 273, says that the validity of a trust and whether or not it's protected from claims of creditors of the beneficiary or the grantor depends upon the law which the settlor declared to govern the trust. And in this case, they said it was Delaware law that did it. So I think that, yes, Michigan had a statute by the time this case went to trial, but it doesn't appear as though the result would have been any different had Michigan not adopted self-settled trust legislation.
I agree with Jonathan. It wasn't mentioned at all, and jurisdiction wasn't even mentioned at all. I'd be curious as to whether that point came up in the Michigan proceeding, but we don't know.
We address, Alan, at some point. I think it'll come up in a few minutes. This claim of the settlor being a de facto trustee by serving as manager of the LLCs, but I think we have a slide coming up on that. Let me just add one point before I turn it back. I'm sorry, to Alan, and that is, even though the case said you had this foot fault, you had that foot fault, and there seemed to be a pretty meaningful number of them, we're still holding in favor of upholding the trust and the plan. When you're affirmatively on the front end planning a self-settled trust or administering the trust, don't rely on foot faults because it's fact sensitive. Another court could see the exact same fact pattern and said, hey, you stepped over the line too many times, we're not going to respect it. So you want to shoot for perfection, but this case is great show that at least one court in this instance looked beyond some of what we'll call foot faults, and we're going to go through some of them as we go through the facts. But start off looking to do those shortcuts. Alan?
Yeah, Marty, this might be contrasted with the SEC case called Wiley, W-I-L-E-Y, where the SEC convinced the court to just ignore the fact that it was supposed to be a separate trust. And the court said, no, we're going to disregard it and claim that the settlor really still had the assets. Now, that has a lot of ramifications, both from an income tax perspective, holding it basically was a grantor trust, so the income would be taxed to the grantor, but also whether or not it would be includable in the estate, and also whether or not it would be subject to claims of creditors. Marty speaks very, very straightforwardly about it. You want to set it up perfectly, and to the extent you possibly can, administer it perfectly. Don't let the grantor ignore the existence of the trust by just saying, well, it's all for me anyway, I'll just take it anytime I want. As you know, there are a number of cases in the Section 2036 area dealing with family partnerships where taxpayers lost because they didn't respect the form. And I've long believed that at least in the tax world, you get the lesser of form or substance. And in this case, I think the taxpayer was very fortunate that the court did not say, well, we're going to not respect the form. They respected the form of the trust, even though, as Marty has pointed out, there were many footfalls as the trust was administered.
Alan?
Yeah, the court was very much influenced by Delaware's corporate law. And, you know, when you try to break the corporate veil in Delaware and the vast majority of states, you've got to have done something really bad. I mean, it's not really bad that you didn't do annual minutes, and it's not really bad that the company paid occasionally some personal bills. It's not necessarily really bad that the company got confused with another company every once in a while. Under that Delaware statute, to protect corporations, as Delaware does, it really takes the fact that you committed fraud against somebody. And in this situation, I think the court didn't directly but indirectly noted that his sloppiness and even the fact that he pulled assets out of the LLCs under the trust to put mortgages on them so he could borrow money, and then he moved the assets back in. I don't think anyone got defrauded by that. So I think the judge knew a lot more about corporate law than trust law and just said, hey, this is Delaware, come here, and we're not going to pierce corporate veils unless you've done some terrible things. And I think there was more discussion really of that than there was of the trust law itself. But the judge just said, well, our trust statute says creditors can't get in, so you can't get in. And the judge said, oh, and by the way, in Michigan, there's a fraudulent transfer action going on. You know, maybe that'll let the creditors in, but that's not my job here as a Delaware magistrate.
On the trust administration side, I thought the opinion was it was interesting where they were, the judge or the magistrate directly addressed the trustee's role, because here the trustee didn't do anything wrong. The trustee was the trustee, and all of the transactions that were at issue were at the LLC level, as Alan just mentioned. But I like the passage, and as an institutional trustee, I really like the passage, because the judge said, for a trust holding solely membership interest in the LLCs, it is not difficult to understand and appreciate such dormancy. The dormancy being that the trustee did not participate in these transactions. And the structure here is one that's not at all uncommon for DAPTs, or for many, even many different types of irrevocable trusts, where the underlying asset is an entity and the trustee is not the manager of the entity. And so there's another individual who is the manager of that entity. Here it was the grantor, but it could be somebody else. And this court was very diligent in looking at the difference. So from a corporate trustee perspective, I thought that was very helpful.
I think that this kind of structure is very common. We see it all the time. Most complex irrevocable trusts, certainly DAPTs as well, tend to own assets with entities because, and Alan, you may want to comment on it, it provides you potentially another layer of protection. What they did in this case is 90% of the LLCs were owned by the trust. Oftentimes what we may do is divide it so you have, no trust owning more than 50%, and maybe even trust owning less than 50%. Alan, you want to comment on that? Because I think that was also an important part of the structure.
Well, I think it's perfectly fine, and I think I would say it's within the standard of practice, if it isn't the standard of practice, that you put valuable assets in a limited liability company. You make the client, who's the one who's willing to be responsible for managing those assets, the manager of the limited liability company. You give him or her a strict fiduciary liability to manage this for the limited liability company, not himself or herself. And you place majority ownership, but not rights of control, under the trust company. And as the magistrates, ended up opining, hey, the trust company signed a valid trust, took a valid ownership interest in LLC interests, and that nothing about that is wrong. And the fact that the individual involved here did not dot all the I's or cross all the T's did not cause that structure to fail. And, candidly, that helps us keep trust company fees under control. If you tell a trust company that they're managing 15 buildings and a shopping center, and by the way, can my daughter work there on Monday and my son wants to work there on Tuesday, the trustee fees will be very high. So, and who else should manage this entity but the person who is the entrepreneur who set it up, who's willing to follow the rules? So it all makes perfect sense, and what proponents in this area have been advising people to do for decades now, maybe if not a century, is generally endorsed here, and the story turns out fine so far, even for the person who forgot about all the formalities and didn't even pay his trustee fees for maybe a handful of years.
I want to
I would just clarify.
I want to emphasize that the result probably would have been otherwise had there been a question of whether or not you're going to have to include the assets in that LLC into the grantor's estate for estate tax purposes. There are probably 20 or more cases where the IRS has been successful, where the taxpayer may have done a slight job of not correctly administering the trust and had ignored its existence or didn't have an independent reason for the formation that could be established. So don't think that this case necessarily is the final word on estate tax planning with respect to partnerships, whether they're in Delaware, Alaska, Hawaii, New York, wherever. You've got to pay attention to the P's and Q's if you want that tax result.
And what I was going to add is, and this is the most important step to help get a plan administered properly, is to get the client to meet, ideally at least annually, or if there's a major event, sometimes more frequently, but periodically, with the entire advisory team. You want everything coordinated as between the trust officer, the attorney, the accountant, whoever else may be involved, because it's so easy for clients to make the kind of footfalls that happened in this case. And had he sat down with an attorney before doing some of the actions, some of them wouldn't have occurred. There was one instance where I think he transferred a real property out of an LLC to his name and then put it back in the LLC. I think it was the same day or just shortly thereafter. I don't think any attorney would say, yeah, that makes sense to do, to go in and out. So we need, and when I say we, I mean, and very much so collectively, all the different advisors and all the different disciplines need to sing that mantra to clients. You gotta have your team help you administer it. It's not intuitive for clients. Alan, you want to go with some more of the facts and we'll work our way towards the planning?
I don't remember much more about the facts. there were a lot of them, but it was just, you ignored it. You took assets out, put assets back in. You didn't pay the trustees. They quit. Then you got another trustee when you finally had to. I can't think really, Marty, of any other fact that other than this was very interesting reading on how to do it wrong and get away with it.
I don't think he did everything wrong. I'd be, I wouldn't be that harsh. He did more wrong than any of us would like to see. So I acknowledge that. Abby?
Yeah, I noted that there were ongoing proceedings about the transfers going on in the other jurisdictions, which I think Alan mentioned, which may, I don't know if that influenced the Delaware court at all, but it seemed like this was another attempt by the creditor, and so I'm curious as to how the proceedings shake out in the other jurisdictions to see if they get at those underlying transactions.
Alan, Jonathan, any comment?
No, I'm in complete agreement with what Abby said.
Abby, would you just run through some of the requirements for a valid Delaware Asset Protection Trust, and feel free to comment how it may be different in other jurisdictions or similar if it is?
Right, well, so Delaware requires, and I am not a Delaware lawyer, but Delaware requires that the transfer is a qualified disposition, which, as I understand, is a conveyance to a qualified trustee. Qualified trustee has to be a Delaware resident or a bank or trust company in Delaware, and that they have that here, and that was very clear and it was easy to prove. The trust agreement must invoke Delaware law, which, according to this case, it did. The trust must include a spendthrift provision, again, according to this case, it did. Must be irrevocable, which, according to this case, it was. Interestingly, the trustee had the ability to make amendments, but it was an irrevocable trust of the grantor. The trustee has to custody some of the property that is the subject of a qualified disposition. So this is not an uncommon. It's the same in Alaska, where we have to hold some assets of the trust, and how much is, there's no statute saying how much the assets or how much of the trust has to be held in the jurisdiction, just some. Records for the trust should be maintained, okay? And the trustee must either prepare or arrange for the preparation of the fiduciary income tax returns or the trustee must otherwise materially participate in the administration of the trust. Now, here I go back to what I said earlier, and that in this case, there would not have been a fiduciary income tax return because it was a grantor trust, unless it was just an informational return. We have no idea if it was. But their statute says the trustee must otherwise materially participate in the administration of the trust. The statutory requirement here, the court reconciled that material participation really was not needed because of the assets of the trust, the assets being the LLCs, and those were managed by somebody else, which I thought was interesting. But those are the statutory requirements. And I think they're pretty similar to other DAPT jurisdictions.
It almost sounds like in some instances, and where clients let us, we try, you almost want to make proactive efforts to corroborate or demonstrate that from. So for example, once in a while doing consents or minutes for the entity and having them signed properly. Making sure there's direction letters if you're asking the institutional trustee to do something on the assets in the trust, the jurisdiction. I try to get close to put enough money in so that covers any of the expenses of the trust, which is usually only misses trustee fees, but for a number of years too, because if there's no fund in the trust and they're not paying trustee, you're heading for problems trying to make the trust respected. So you practical, not just hypothetical number that you think gives you sufficient nexus. Alan, Jonathan, any comments before we go on?
Let's go.
Okay, Alan, Jonathan, did you guys want to comment on the position of the court?
Yeah, I thought it was interesting. I researched this a little bit. Delaware is a very small state, so you just have the trial court and then the Supreme Court. There's no middle appeals court, and it seems clear to me that the Supreme Court would uphold this if it gets appealed. I don't know if it's getting appealed or what the deadline would have been for appeal.
I mean, the case seemed fairly strong the way the court worded its holding. I mean, Jonathan, do you feel there's any likelihood of an appeal?
Marty, I really don't know. I just don't know the players, and you couldn't have, if you were the party suing to have this basically set aside, I don't think you could have a worse decision. I also think that the chances of the Delaware Supreme Court knocking this down is very, very small. I mean, Delaware, which has been already remarked, is a very small state, and a huge portion of its work is from corporations and from trust matters. And I don't think the Delaware Supreme Court would do anything to upset that. There are other cases where the Delaware Supreme Court has acted, which I must say I was really surprised, but they came down entirely on the side of just absolutely upholding the trust in its entirety. There was one where a trust said it would be governed by the law of the state of New York. And yet the Delaware Supreme Court said, yes, we know that's what the trust says, but we have it now in Delaware, so we're going to apply Delaware law. They really want that business, and the lawyers, and more important perhaps, judges in Delaware and the Delaware legislature knows how important this work is for the state of Delaware. So I don't think that the Supreme Court would dare touch this. And I don't know on what ground it would. I mean, it could say, well, we're relying on the fact findings made by the trial court, so we don't even have to discuss it. But even if it got into the details like the trial court here did, I think that it would be highly unlikely that the Supreme Court of Delaware would strike this down.
Alan, you want to comment on the full faith and credit and the manager participation by the grantor? You want me to start it off?
You can, sure.
So one of the things that I think is very powerful and very interesting in this case, and I was happy to see it because, like Alan said, we've been doing this for forever, and now we actually have a court case that says it works. So here's a typical trust structure. Is you set up whether it's a SLAT, a DAPT, a hybrid-DAPT, a SPAT, or any kind of variation of an irrevocable trust. Very common destruction is directed trusts, where settlor is either an investment advisor, investment trustee, depending on the language you use and the way you draft. And in that capacity is responsible for the decisions made as to the investment assets held by trust. And trust companies like this, because as Alan explained, most trust companies want to get actively involved in managing a family business or a rental property. The liability exposure is significant. And there are trust companies that have expertise in this, but they charge according for the risk and responsibility they're taking on, as they should. So an awful lot of trusts are structured as directed trusts. And the next piece is the underlying entity, which Alan explained. You need someone to manage. You can have a member managed LLC, but then who's signing anything? Who's taking actions on behalf of the LLC? In some instances, it's fine to have a member managed LLC. But if you have an active real estate business and you need someone to sign a bank loan, a lease, you really want a manager, because who else has authority to sign? You're going to go back and issue a direction letter to have the trust company sign. I mean, that can be done too. So the question becomes, and the court spent some time looking at this, is you now have the settlor who created the trust serving as the investment advisor or investment trustee, and as a manager of the underlying entities like the LLC that own the underlying properties. And it's very commonly done. So one of the questions that has always sort of been pondered is the fact that the individual who set up the trust and made the transfers serving in both roles, investment advisor or trustee and manager of the underlying LLC, does that taint these assets as being reachable by creditors or included in the estate? And it was on the basis of that, plus some of the wonky transactions that were done. I think Alan used the word sloppy, but does that taint the ability of the structure, not just the trust, but the entities and the administration of it, the plan and the structure to survive an attack? Going back to what Jonathan said, is just because they made it past the creditor claim doesn't mean they're going to make it past deflecting an estate inclusion claim. It seems, and Jonathan, Abby, Alan, please comment. It seems to me that you can be in those positions. It's not a tax sensitive power, and you should be able to have the structure respected, not just for creditor purposes, as in this case, but even for estate exclusion purposes. But it seems to do that, you have to be careful in what you do. At some level, and Jonathan's, I think part of his point was the tax level may be much lower than the asset protection level. At some level of either sloppy or self-serving or inappropriate transactions, the IRS is going to say, no, it's not outside of your estate. You know, if you have, the personal expenses written off on the LLC, many of us see clients pay their estate tax bills, planning bills, out of the entities owned by a trust. Well, estate planning is personal to the client. They shouldn't be paying it out of the trust. That's an infraction. How many infractions and how big of an infraction and how dollar-wise sized of an infraction can you commit before you jeopardize the asset protection or tax benefits? But the case upheld from an asset protection perspective, this worked. But as we said earlier, you want to strive for the right result as best as you can, because there's always inevitable footfalls. Everybody needs something. Comments?
Well, it's also appropriate to keep in mind that the law seems quite certain that if you create a trust and the grantor's creditors can access the assets in the trust, you're going to have estate tax inclusion. That's Revenue Ruling 76-103. So if you have a trust where creditors can attack the assets, attach them, then you're not going to have it excluded from the estate no matter what you put in there. Again, the distinction here is they weren't looking for estate tax exclusion. They were merely determining whether or not they would respect the existence of this trust for purposes of creditor claims basically under state law, which is an entirely different thing. One interesting issue, which Marty hinted at the beginning, is what would have happened if the case had been brought in another jurisdiction, perhaps a jurisdiction which doesn't have any self-settled trust legislation at all, or one where you're not going to get the kind of tremendous decision that you got in this particular case in Delaware.
What do you think? I mean, isn't that the $64,000 question? If my DAPT is in Alaska and I live in New York, which is not a DAPT jurisdiction, we still don't really have a clear answer on that.
Well, Marty, we think that if you respect the form of your DAPT, which you have in Alaska, and you've had that there for, over 20 years now, about 25 years, that it would be respected for tax purposes. But the question is, if someone now brought a claim against that trust, say you owed somebody money, and that creditor came in and said, look, I know this is an Alaska trust, but for purposes of being able to attach it, I think we have to look at the law of my home state, or where the action against the grantor began. And that, I think, is not as clear as it could be. One of the things that I've urged people, despite this case, is do everything you can in the DAPT jurisdiction. You only want trustees in that jurisdiction. You don't even want a trust protector in a jurisdiction which doesn't have strong self-settled trust legislation. If you really are doing this for purposes of protecting the assets, you have to go many, many more miles than happened in this particular jurisdiction.
One of the things that we routinely recommend in the context of like a case like this, if you're going to have LLCs own real estate and your self-settled trust is set up in Delaware, but your real estate's in New York, set up the LLCs in Delaware. Just another, I'm not saying it's going to make or break the case, but it's another connection or tie to Delaware, and have them authorized to do business in the state like New York where the properties may be located. Just another connection. If you have individuals that you want to name as a trust protector in the home state, you could wrap them inside of a entity to serve in that capacity and name the entity as the protector. Any comments, Abby or Jonathan, Allen?
We've seen that a number of times where the trust protector will be an entity, could be a Delaware LLC or an Alaska LLC. So Marty, I mean, that's a technique that is used. I haven't seen it tested, but it's certainly used, and I would say it's not uncommon. And then having the asset held in an entity formed under the same jurisdiction as the trust is also a common practice. So Alaska Trust having Alaska LLCs and Nevada Trust having Nevada LLCs. And this is not uncommon at all. And for what it's worth, it does create more nexus to the jurisdiction, at least one more layer.
Can I quote you, Jonathan? Jonathan,
Yeah.
Can I quote you?
Sure.
You
go
always
ahead.
say you don't want to be the low-hanging fruit. So
No, you
if
don't.
lots of other people out there have a home state trust protector, and your trust protector is functioning through an entity formed in Alaska where the trust was formed, I think it helps. We can't quantify it, but it helps.
It really does help. I mean, as a general matter, a number of states in theory could have jurisdiction over the trust. Typically, I think the law indicates that you have jurisdiction over the trust if you have jurisdiction over the trustee. So again, I would make sure that you do your very, very best to have only trustees in the state which provides asset protection. In addition, you want to make sure that your trust protector, there's a case in New York called Ileana, which suggested that even somebody who holds a power to change terms of a trust, perhaps as a trust protector, perhaps not, the case doesn't really state that would be sufficient to allow New York to have jurisdiction over it. And in that case, the question is, would the trust be respected for purposes of getting benefits from the state of New York. And the court said no, because a New Yorker could go ahead and put the grantor back in as a beneficiary. We're not going to respect the existence of this entity. So you've got to be very, very careful on what you're trying to achieve. Go that extra mile, go the extra 2 miles in order to make it as bulletproof as you possibly can. I just can't tell you how significant that really is, how important it is to make sure you do everything. You have proper administration, you have proper, documentation of what you've done. Use entities which are located in DAPT jurisdictions. For example, let's say you have a piece of real estate in New York and you want that to be in an asset protection trust. Well, put it into an entity, perhaps doing it in an entity in Alaska or Delaware or South Dakota or Nevada, where you're going to get good protection. And you're going to, even though you may wind up paying additional fees for registration or operation, it's worth it if that is your goal, is asset protection. I mean, I'm not sure that another state would be quite as generous as Delaware has been in this case, if you had it, say, in another state, even if it's a self-settled trust state. I'm just not sure. As Alan has pointed out, this seemed to turn on how strongly the courts in Delaware will respect a corporation. And the fact that it relied on corporate principles and not trust principles may make this decision somewhat suspect. I would do even more if someone said, but I really want this to be protected. I would do much more than just say, well, I'm going to do it in Delaware. We now have a case in Delaware. But again, when you read the case, you'll realize that it was kind of a thin reed that the court grasped onto to pull itself outside of having the assets attached.
Alan or Abby, would one of you want to comment on the full faith and credit? We've kind of talked about it, but I think we should talk about it for just a few minutes more directly and then mention the Huber case.
Abby, do you want to handle that?
Oh, I was gonna ask the same of you.
Well, the full faith and credit clause in the United States Constitution says that a judgment passed by a judge in one state has to be given full faith and credit by a judge sitting in a sister state, another state. And we just have not had a case yet where one state judge has declared a asset protection trust to be against public policy and unenforceable. So stay tuned. It's been more than 20 years, which really, by the way, goes to show that these trusts don't get challenged very much. The experience that a lot of us have had is that when a bank or a creditor sees an old and cold irrevocable trust, even where the grantor is a beneficiary and it's in an asset protection jurisdiction, they just say, could you please write us a small check so that we don't have to write a small check to go to Nevada or Alaska or Delaware to challenge this. But nevertheless, you have to warn the clients that the full faith and credit clause is out there. We always also let the clients know that if they want to do an offshore trust in a country that does not even recognize U.S. judgments, they can. But this can be more severe. You could end up with a contempt of court threat against you. You could forget to report the trust on your tax return and pay a penalty of more than 35% of the value of the trust assets. But we can't promise our clients that everything we do for them will be beyond challenge. And the full faith and credit clause is certainly a threat that we feel and have to be understanding of when we do this work.
I think the concerns about that were existing from the first time the first state enacted a self-settled trust legislation, which I believe was Alaska in 1997. So since 1997, people have been talking about the risk of full faith and credit. One of the cases, and I believe it to be the only case, was Huber. And in Huber, Washington said, we're applying Washington law, not Alaska law. And I don't mean to speak too broadly, but I think every practitioner that's looked at this said the court was wrong. It was clearly a fraudulent conveyance. They should have said it was a fraudulent conveyance, told the defendant he lost, and end the discussion, not say that they were applying Washington law to an Alaska case, which is, I believe, what the court did. And the reason it was a fraudulent conveyance is when the individual who set up the self-settled trust in Huber set it up, he was in default, I think, on a couple of 2 or 3 loans that he had guarantees on real estate deals, and he was in a lawsuit with his real estate partner. You don't make transfers when you're in default on 3 loans and in a lawsuit with your partner. I mean, you don't do that. So it was.
Yeah, and what he transferred was Washington real estate as well, if you read the appellate briefs.
So it just, to try to extrapolate from a case like that, I think is very difficult. Are any of you aware of any other cases that have seemingly tried to apply the home state or the local state where the real estate was law as opposed to the DAPT jurisdiction state other than Huber?
I have not.
So we have one case that seems wrongly decided with really awful facts. And in all these years since 1997, that's it. Any comments on the mission pact? I think we may have covered, unless any of you have more thoughts.
No, it'll just be interesting to see what these other proceedings, how they shake out. There's also one.
Would you guys? How about if we jump to the lessons of the case about planning? Because I think that's really the bottom line for practitioners. Okay, we have a case, it has some good stuff in it. I can have my client be the investment advisor and the manager of the LLCs, but what more do I need to know? And I think we have a pretty good checklist of planning ideas, and perhaps we can wrap up by going through that. Abby, you want to lead it off? Alan?
Sure. I mean, the first lesson is the first having good reasons for the plan. And the plan should be created, this is for asset protection purposes, before there's even an issue. So, and that was the case here, where the trust was created long before the grantor even borrowed money from the creditor. So that was helpful. But having solid reasons for creating a plan and documenting those is really the first critical step. And then, as I just mentioned, the timing was critical. So setting up a DAPT after a creditor problem arises is not good planning. The good planning is setting up a DAPT before there's any issue whatsoever.
Agreed.
Alan?
I mean, I agree with what Abigail said. It's a good idea to have a business purpose besides just creditor protection. And I was wondering, Jonathan has made a great observation. He didn't have to be a beneficiary of this trust. He could have just had his spouse or his floating spouse and his descendants as beneficiaries. He could have given somebody close to him a power of appointment that maybe could have added him as a beneficiary or appointed to have him become a beneficiary. So these types of things, certainly come to mind as alternate ways to design these trusts if you're concerned about what the result might be.
Some clients want to see their name there. They don't even want to see descendants and grandparents. They want to see John Doe, I'm here.
Well, on the trust administration side, what we're starting to see is divorce, especially with spouse. So the impact of divorce, and that can be a very scary prospect for a grantor who has put a significant amount of his or her wealth in an irrevocable trust for others, and then gets divorced and loses access to the trust. So there are two sides to that.
Just to echo what you've just said, I worry that what Abby just said, the risk of divorce in any of these large irrevocable trust transfers, plans that transfer large amount of wealth to irrevocable trusts, that divorce is a far greater risk, for example, in SLATs than the non-reciprocal trust doctrine. So yeah, we all need to be mindful of that.
Divorce is not, statistically, divorce is probably also worth a higher risk than a creditor problem.
Yeah. I'll cover this slide real quick. The trust has to be irrevocable. That was one of the things Abby read in terms of the requirements of the Delaware statute. Local lawyer, when we do a trust in a trust-friendly jurisdiction, we have local counsel review the trust for local law and give us an opinion saying that the trust is valid under local law. We shouldn't be, it's not just the issue of the unauthorized practice of law, but we shouldn't be the client Achilles heel by not involving a local attorney. Alan, you want to talk about spendthrift?
Well, other than to say you certainly want to have a spendthrift clause in the trust agreement. And this trust agreement had a spendthrift clause.
Any comments on the content of the clause or?
Well, Interactive Legal has a very good spendthrift clause. But I don't think the spendthrift clause itself has to be that fancy. There's language here. It just needs to be a spendthrift clause that qualifies under state law.
Got to be right. Jonathan or Abby, maybe even Abby, you want to comment on the benefits of an independent trustee?
Happy to. I mean, I think there's a number of benefits for an independent trustee, one of which is here, well, I mean, here the grantor was not a trustee at all. He was the manager of the LLC. But if this had been a different case where we were looking at transactions of the trust, the independent trustee adds that extra layer of being more objective, and it's one less thing that the creditor can argue about where the grantor retains control. Because trust administration is so important and how they're administered, it is helpful to have a trustee that knows what it's doing and knows the role and knows what not to do. Right. Of course, I'm a fan of corporate trustees, but I'm with a corporate trustee, and I think that's a helpful thing. But no matter what, you need an independent, or you should have an independent trustee, at least in charge of distributions. Although there can be a distribution advisor, and that is allowed in directed trust as well. So there's a lot of ways to set that.
Let me add that I think that if you have an independent corporate trustee and the independent corporate trustee gets on the stand or a representative says there was no understanding between us and the grantor as to how the trust would be administered, it was entirely up to us. And we really meant that. I think you're better off than having, your brother or your sister or your college roommate or your best friend in there, where the trier of the fact may say, well, yes, they said he was independent. They said there was no understanding, but it may well be that you're going to lose on that the court's just going to find it incredible that you put in, your roommate from college who is not a professional trustee, and you made him or her the trustee with all sorts of powers, and there was no discussion between the grantor or the grantor's representative, like the grantor's lawyer and the trustee. I think you're always better off having an independent person because the credibility of that person at some point may be challenged.
And from a tax perspective, the Levine case, which was a split dollar insurance case, it seemed significant to the favorable holding in Levine that they had independent trustees. One trustee that was an individual who was the fiduciary, I think the agent of the power of attorney, was an independent business partner, but he had business acumen. He was not a family member, independent, but they also used an independent institutional trust company in a trust-friendly jurisdiction. And the court expressed how important that was. And there's other to the same conclusion. one of the things that's very important if there's ever a challenge, whether it's for asset protection or institutions, you know, the things that everyone complains about, oh, they always want a piece of paper, always want a letter, you know, they have to have a committee meet to do anything. Well, but that's the power and the benefit of the institution, because now you have a committee that has to meet to approve a distribution. It's not like, you know, Uncle Joe or Aunt Jane just write out the check you ask for. The process, the policies, the procedures are what is protective of the plan. And I think a lot of clients, including the settlor in this, try to circumvent that. You don't want to circumvent that. It's actually very positive. Meetings, you know, the court respected the underlying entities here, but you know, how do you feel, Alan, about having periodic meetings or even a consent by an LLC or partnership or corporation?
We send out meeting minutes to the clients and their CPAs every year. And in the old days, I used to wait for the CPA to tell me what to do in the minutes, and that didn't work. So we send the minutes and we say, here's your draft minutes, please improve them or at least sign them and send them back. And
I think that's really important.
Yeah. And then every 2 or 3 years, I go and visit the trust company that our clients use the most, and we have minutes of meetings with me and the trust company and the client on the phone, on the speakerphone, that we did meet in that jurisdiction to talk about the trust, and we reviewed what the trustee was holding, and we all had a great time at that meeting. So I think all those things help. You never know what factor will help the most, but maybe those things aren't needed, but they might overcome something else that you're not expecting or that you don't know about.
Right, and as Marty said before, my mantra has always been, don't be the low-hanging fruit. So even if you don't do it perfectly, if you have all those provisions in there and you respect at least some of them, that's not the case the IRS is going to want to have. It's going to want one where people just disregard it. They didn't have meetings. They didn't send notes. They didn't do all the things that we said should be done. But at least if you've done some of them, you're going to be better off than if you've done none of them, including if you have someone like the Internal Revenue Service come in, it's going to want to go to the low-hanging fruit.
And if you do what Alan said, you have documents to show that you were trying to respect the entity and the trust and the plan. If you don't take those steps, because LLC statutes are by design default statutes, which is great because a small business can kind of just, you know, use what's in the statute. If they don't do something, there's a statutory default. But how do you then show, yes, we were affirmatively respecting it? It may have been fine what you did under the statute, but how do you show that? So I think the kind of records Alan's talking about are helpful. And in this case, keep in mind the challenge. The plaintiff argued that the defendant settlor set up the trust, was the trust, I don't know if it was an investment advisor or trustee, but was the investment advisor and the manager of the LLCs, and there by virtue of those positions, acting as the trustee, which is not a foregone conclusion, but wouldn't it be nice to say, well, hey, here's our trust meeting notes, here's this notes for the entities or unanimous consent, the underlying LLC. Having show that you respect the mallet can only help. Trust protectors. Alan or Jonathan, you want to comment on the benefits of trust protectors?
Well, trust protectors provide for, you know, more flexibility in getting changes done. This is a concept which I think I was the first in the United States to use, but it came from advice given to me by a Liechtenstein lawyer, where you would have someone other than a trustee in the country have some power to control things that the trust did. It's a great idea. It's very common. In fact, many states now have statutes dealing with trust protectors. But, you know, you can call them whatever you want. But you want to make sure that if you have them in there, you're not giving jurisdiction to some place which you would not want to be. So if you put the settlor's brother in there as a trust protector, you can bet some creditor will try to glom onto that, or the IRS will glom onto that for purposes of trying to ruin the plan you've set up.
And just to add to that, in the mind of what we said earlier, the trust protector can be an entity. So that's another option. So I would presume, Marty and Alan, that some of your clients don't necessarily have a large circle of individuals in a DAPT jurisdiction that they would want to name as trust protector. So this is where the entity might be helpful.
Just quickly on the next slide, I think we've already really talked about it. You have to limit what the settlor's role is. The case said that being an investment advisor and manager of the LLC is fine, but you want to do those things properly and with respect to fiduciary capacity. You want to eliminate some of the funky things that were done in the case. I think we've already talked about distribution powers. My preference, unless the client is adamant, is to have the institutional trustee hold those powers because it's a very tax-sensitive power. Abby and others have already commented on trust administration within the state. We've commented on foot defaults and some of the odd stuff that was done in the case, and they won despite that, but those are things we should strive to avoid. Any comments on the LLCs? I think we've talked about, Alan, that it's fine to have 90%, but you may want to break it up and have 50% in different trusts. It's perhaps a better level of protection. Proper documentation for the LLC. I think your point about periodic minutes and meetings is great. Anything to add to that? Because I think we're pretty much at the end of time.
No, I think you've covered it very well, Marty.
One of the things, and I'll do it in 1 second, on even the plan in this case, you had a trust that was formed by a Michigan settlor in Delaware. You had 3 underlying LLCs that own properties. If you add up all the different documents to make this plan work and to administer it, it's a lot. I recommend a checklist. Many clients, not all unfortunately, let us set up a checklist. It does take some time, but I think as the documents and the complexity of the plan start to proliferate, a checklist is not only great to make sure you don't lose sight of documents, makes it really much easier to administer the trust, and can make it very easy to collaborate by enabling everyone to see what's going on and where we are. Abby, you want to make any final comments, and then Alan to wrap it up?
Thanks, Marty. I think this was a good case, and that's it. Appreciate the opportunity to share it all.
Alan?
I represent a lot of people who come to me shortly before a trial, unfortunately. But what they tell me is, well, my brother-in-law is a lawyer, and he told me that these things don't work. So I never did one, and I'm single, and now I have a lot of assets exposed. What do I do? And I can't say, well, go sue your brother-in-law. But, there are a lot of advisors out there who aren't clear on whether it's appropriate to recommend or consider a domestic asset protection trust, especially if you're domiciled in a non-APT jurisdiction. And I think the answer is you need to offer it to the clients because they may work, and in reality, they most commonly work when you're in negotiation or when you're trying to get a plaintiff lawyer to settle a case based on limits of liability, because the only thing they can get above that is what they could try to get out of a Delaware asset protection trust. So it's nice to be perfect, and it's nice to say you have to have a trust protector who's over there. You can't have your brother as the trust protector. You can't touch the assets underneath the LLC. It's great to try to say that, but then if the client says, well, is it better than nothing? Well, what this guy did with his brother as the trust protector, and he had his hands on the assets, he didn't pay the trustee fee, he's still coming out ahead, it looks like to me. The offers to settle after this decision came down probably were more in his favor. So I'm not going to require my clients to be perfectionists, but I am going to offer them and educate them and do what's in their best interest. In this case, just gives us some more tea leaves along the path that we follow to do the best we can for clients in the most efficient and effective way.
Thank you, Alan. Thank you, Jonathan, who had to jump off. Thank you, Abby, and good luck to everybody. Thanks for joining us.